Hey NoteTakers, welcome to my YouTube channel. If you're a returning viewer, thank you for tuning in and welcome back. If you're a new viewer, welcome. I hope you enjoy the videos because we have fun this side. If you're a subscriber, thank you for subscribing to my channel. If you aren't a subscriber yet, what are you waiting for? Click the subscribe button to join in on the fun. Don't be shy. Alrighty, let's get into some case law. Okay, today's video, I'm just going to be going through my background, my disclaimer, Rhea cases it, I'm going through a case, how I came to know the case, then we're going to be going through the case, looking at the act or acts involved, looking at my 3 model case law steps. Then we'll move on to my thoughts on the case, and then lastly, closing remarks. Alrighty, let's get started. Just some background on myself. My name is Rhea, but I prefer Rhea. I am currently a 4th year UNISA BA law student, wanting to engage with other law students, individuals who are lovers of the law, soccer fans, and to connect with viewers from around the world. If you have any content suggestions or just wanting to reach out, feel free to email me at rheanoted@gmail.com. Again, my channel email is rheanoted@gmail.com, where you can share your law student experiences and even share some feedback. Also, I just wanted to remind you guys to check my post section on YouTube regularly. So if you want to go to my post section, so this is like my channel, there's home, there's playlists, and then there's posts. I post regularly there, so make sure to interact with that section of my YouTube channel. Before I start, I just wanted to again say thank you to my subscribers. Thank you, thank you, thank you, thank you so much. Let's say it all together. Rhea Noted will grow, Rhea Noted will do well, and Rhea Noted will reach more people. I'm manifesting. Alrighty, so just a little disclaimer notice, just as a safety precaution. So just as a safety precaution, I'm just trying to be safe legally. I just want to make sure that it's known that I am discussing cases in my capacity as a law student. I'm not an attorney, lawyer, advocate, in any way. I'm just a student. I'm not an admitted attorney or advocate or lawyer. I am discussing cases by making use of my knowledge as a law student and also making use of my own opinion and interpretations. So once again, I'm just discussing cases from a law student perspective. Let's just get that out of the way. Alrighty. So this video will be going in the Rhea Cases It playlist. You can check out my playlist in my bio. In the Rhea Cases It playlist, I just go through cases that interest me. So it'll be under that playlist. Okay, so today, for this video, I will be going through a court case. I came across the case while doing my company law module, or LML 4806. This module was super fun for me. Basically, me and the Companies Act became besties. So, yeah. My average was 72%. It's all good. I think both assignments were written assignments. So for assignment 1, I got 80. For assignment 2, I got 65. So all in all, it was a fun module. The case I will be going through deals with the Companies Act. So obtaining a copy of the Act would be a good idea when reading the case. So it's easy when certain sections of the Companies Act are referenced in the case. And the case I'll be going through today is Richard Duplessis Barry v. Clearwater Estates NPC and others. I don't know if I pronounce it. Richard Duplessis Barry. Okay, hopefully I said it right. And for me, the shortened version is Barry v. Clearwater. So here is the Companies Act. And you can download it. So when going through the case, it's close. In my studies, I've come to learn that reading court cases is a very good skill to have. You'll be reading a lot of cases. As a law student and probably working in the legal field, I think it's referred to as case law because you're reading a lot of court cases that deal with acts of parliament, the constitution, legislation, and statutes. I kind of look at case law as a collection of court cases that deal with important decisions that will impact future court cases. Just think of case law as a collection of important South African court cases. So for ease of reference, again, this video will be in the rear cases it playlist. So when I was in first year and I came across my case, I was so confused. I was like, what's happening? The format, the wording, the abbreviations, it was so confusing. I will say the Skills Course for Law Students module, or CSL 1501, really helped me out. My advice is to practice reading different cases to get better, because the more you practice, the better you'll get. So pages 47 to 62 in the SCL 1501 study guide are incredibly helpful. There will be some instances where you are required to read a case for an assignment or refer to a case. So knowing how to read a case as a law student is really quite beneficial. So when I had to get a case for an assignment in the earlier days of my studies, I didn't quite know where to begin, but I finally came across SAFLI, also known as the South African Legal Information Institute. So when I'm looking for a case, normally I just type the name of the case into Google. So for today's video, typed into Google. Then a SAFLI link comes up with the name of the case. Like today's case, Barry v. Clearwater. Yeah, and then I just download the case. Alternatively, you could go directly to the SAFLI website. Then go to the search page, search using the name of the case, and then download the case, whichever works for you, as long as you download the case. For example, for today's video, I'm going through the Barry v. Clearwater case. So I can either Google the name, see the link, and download the case, which is what I did, or I go directly to Safely, search for the case, click, and download, whichever one you prefer. I have developed my own steps, I'll say, that I use when I'm reading a case, and I really, really, really hope these steps will help you too, note takers. Before I get into these steps, I will include a link to the case if you'd like to read the case for yourself, if you'd like to read more, or if you'd like to dive deeper. So there'll be a link of the case, there'll be a link of the Companies Act, so it's just easier for my note takers. Okay, so these 3 steps have truly helped me. Let's call them, I've dubbed them RIA's 3 model case law steps. I hope it helps you guys. Okay, the first step in RIA's 3 model case law is finding the case. So I've already established that going to Safely will definitely help you find the case. Once you've downloaded the case, the next step, step 2, is skimming the case. Okay, so usually when I'm skimming, what I do is, okay, I check how many pages the case is, which court the case was held in, the name of the parties involved. If the case deals with a certain act, then I know, okay, I need to download this act for ease of reference. And then step 3, the last case, the most important step for me, the deep dive. What I do in the last step is I start to read the case from the very first paragraph to the very last, thoroughly, obsessively, meticulously. I make super detailed notes, and where I find a point that I deem interesting, I write it down, and I write down the paragraph number. For me, I feel like writing the paragraph number is incredibly important because sometimes you might need to go back to an important point, and you might find you forgot to write the paragraph number. It's also important to note the paragraph numbers when you're reading a long case, because there are short cases, there are long cases. Just paragraph numbers is my advice. Okay. So like sometimes I also like taking a piece of paper, like an exam pad. I tear out the page, I fold it in half. So one half of the page is for one party and the other page is for the other party. That's what I did for the case today. So one half of the page has the heading Barry, all his information, what party played in the case. Then the other half deals with the respondents section, what they did, what they involved in, because in this case there are 3 respondents. So hopefully RIA's 3 model case law steps help you as you read court cases. Remember, step number 1, finding the case. Step number 2, skimming the case. And step number 3, deep diving into the case. Okay, so let's apply RIA's 3 model case law steps to today's case. Okay, so we start with step 1. As you guys saw, I prefer the system of searching for it in Google, it coming up with the Safely link, clicking on the link and downloading the case. So, okay, I've completed step 1. I have searched for the case, I found it, I've downloaded it. Now we move on to step 2, skimming the case. Okay, so the step consists of skimming. So, like the page numbers, the parties involved, and all of that. So, the case is 11 pages. We can see here the case was held in the Supreme Court of Appeal. You can see here the parties are Richard Duplessis Barry, Clearwater Estates NPC, Kevin Olivier, and the Commissioner of Companies and Intellectual Property Commission. Okay, before I move on to the last step, I just want to emphasize how helpful pages 47 to 62 in the SCL 105 study guide are. Okay, then lastly, I see, okay, this case deals with the Companies Act. So then I'll download the Companies Act, use of reference. Okay. Then we move on to step 3, the deep dive. Okay, step 3 is all about reading the case while making sure to write the paragraph numbers of the case that I feel are important. Make sure to write the correct paragraph numbers because you will thank yourself in the end. Okay, now that I know the parties of the case, that the Companies Act is necessary, I've kind of laid a foundation. So I can now dig deeper. Okay, so the appellant can be described as he who is appealing against a decision the court made. In this case, the appellant is Richard Duplessis Barry. From here on, I will refer to the appellant as Barry. The respondent can be described as he who is responding. In this case, there are 3 respondents. The first respondent is Clearwater Estates NPC. From here on, I will refer to the first respondent as Clearwater. The second respondent is Kevin Olivier. From here on, I will refer to the second respondent as Olivier. The third respondent is the Commissioner of Companies and Intellectual Property Commission. From here on, I will refer to the third respondent as the Commissioner. Let's dive in a bit deeper. So, the JA stands for Judge of Appeal, and the AJA stands for Acting Judge of Appeal. Okay, now we're starting our super deep dive, so buckle in. Okay, so Barry, the appellant, he is seeking an order to declare all the business and resolutions that took place at a special general meeting be unlawful and void. As we can see here in paragraph 1, Basically, Barry wants any business that occurred on 27 September 2014 at this special general meeting be declared unlawful and void. Why would Barry want that? And what happened at that meeting? Paragraph 3 explains what happened at the meeting. The meeting was held by Clearwater. The meeting was on a Saturday meeting, and the meeting was about a resolution. This resolution would increase the levy payments of residents. You can see an increase in the levy payments. But by how much? According to paragraph 7, the proposed increase is about 272 Rand 50 cents. Clearwater wants to go from 45150 to 724 per month. That's a lot of money. The validity of the resolutions that were passed at this meeting are being challenged because of the shareholder proxies. Articles 13.710 and 13.711 of Clearwater's MOI deal with proxies. Let's first look at what the definition of an MOI is. MOI stands for Memorandum of Incorporation. The definition can be found in Companies Act, which you would have already downloaded. So basically, the MOI is a document that sets out the rights, duties, and responsibilities of shareholders, directors, and others within the company. So, just remember, Barry is the director of Clearwater Estates. Olivier is the chairperson. Let me get this here. Chairperson. Okay, let's examine and break down Article 13.7 and Article 13.711 of Clearwater Estates Memorandum of Incorporation. Remember, the MOI sets out the rights, duties, and responsibilities of shareholders and directors. Okay. So first we're looking at Article 13.7.10 in paragraph 10. So if I were to summarize 13.7.10, it would be that an instrument that's appointing a proxy and power of attorney, and any power of attorney has to be done so no less than 48 hours before a meeting where voting is to take place. Article 13.7.11, also in paragraph 10, if I were to summarize it, it would be that according to Clearwater's own MOI, where a power of attorney or proxy isn't placed on time, it shall not be treated as valid. So it is invalid. Paragraph 4 has an important note, in my opinion. It says that Article 13.3.2 of Clearwater Estates MOI states no less than 25% of voting rights be present when you're passing any special resolution. So basically, there can't be less than 25% individuals present when you're voting to pass a special resolution, any special resolution at any meeting. Paragraph 5 looks at how the board at Clearwater Estates proposed a vote that would allow for the late filing of proxies. And this late filing was accepted by the majority. It says here the board proposed a vote condoning late filing, which was accepted by the majority. But didn't the MOI explicitly say that if a proxy isn't deposited timelessly, it will not be valid? Here, if it's not deposited timelessly. So, is Clearwater Estates going against their own MOI? The late filing of the proxies was accepted at this Dodge and SAS special general meeting on 27 September 2014. So once the late filing was accepted, the contested resolutions were voted on and passed. Don't forget the 27250 levy increase. It seems to me that Clearwater Estates ignored their own MOI to somehow justify the resolutions. It doesn't make sense. Okay, paragraph 5 has an incredibly important point, in my opinion. It says the meeting wasn't properly constituted as no special resolutions could be passed in the absence of the requisite quorum. Basically, Barry is saying, no, the meeting wasn't properly conducted, special resolutions weren't passed properly, and the requisite quorum wasn't adhered to. The minimum number wasn't present. To me, it seems that Clearwater Estates was trying to change or amend the MOI to suit themselves. So, Clearwater's excuse is in paragraph 6, basically saying Articles 13.710 and 13.711 conflict with Section 58.1 of the Companies Act. This is Section 58.1 of the Companies Act, where it says at any time you may appoint an individual as a proxy. So, Article 13.1710 basically states that a proxy may be appointed no less than 48 hours, while Section 58.1 states that a proxy may be appointed at any time. In Clearwater Estates' eyes, Articles 13.710 and 13.711 are in violation of Section 58.1 of the Companies Act. Paragraph 7 beautifully sums up where each party stands. So, Barry wants to uphold articles as they will help quash the resolutions, but Clearwater Estates wants to annul the articles to preserve the validity of the resolutions. Legal tug of war. Paragraph 13 shows how Judge of Appeal Swain thinks provisions of Section 58.1 of the Companies Act are unalterable. So Section 1 of the Companies Act, it gives a definition of what an unalterable provision is. It means a provision that means a provision of this act that doesn't expressly contemplate that its effect may negate, restrict, or limit, qualify, extend, otherwise altered. Basically, it's saying a provision cannot be altered. Remember, Section 58.1 discusses how a proxy may be appointed at any time. The Judge of Appeal is simply saying this section, Section 58.1, is unalterable, meaning this provision can't be changed or altered by a company's MOI. Moving on to paragraph 15. Clearwater Estates states that appointing a proxy can take place at any time, but the MOI says no less than 48 hours before the meeting. This time clause contravenes Section 58.1, is inconsistent with Section 58.1, and is void. Paragraph 23 states how the provisions of Articles of Clearwater Estates MOI are inconsistent with the provisions of Section 58.1 and are void in terms of Section 15.1 of the Companies Act. So, from my understanding, Articles 13.710 and 13.711 are inconsistent with Section 58.1 of the Companies Act. On the one hand, the articles say appointing a proxy is to be done 48 hours before a meeting, but Section 58.1 of the Companies Act says the appointment of a proxy can take place at any time. So there's a clash, an inconsistency. Also, these articles are void in terms of Section 15.1 of the Companies Act. So, because the articles of Clearwater Estates, because the articles of Clearwater Estates MOI are inconsistent, the provision is void. Basically, Articles 13.7 and 13.711 aren't valid and are null because the articles aren't in line with the anytime stipulation provided in Section 58.1 of the Companies Act. Interesting. Very, very interesting. And there you have it. The completion of AREA's 3 model case law steps. We found the case, we skimmed the case, and we dove deep. I really hope I analyze it properly and that you guys understand. So now that we've completed the steps, I would like to give my own opinion. When I started reading the case, I was biased and I was totally on Barry's side. It seemed to me that Barry was using the law for good to fight the levy increase that was decided upon in an unfair manner. It also seemed to me that Clearwater Estates was using the law in an unfair manner and to use the law to justify that levy increase. But my deep dive showed it isn't so simple. Instead, the law was used in an objective way, which is really important, objectivity. The appeal was dismissed. Barry's problem was that the proxies were submitted on 27 September 2014 and that the submission was in contravention of Articles 13.710 and 13.711. The articles state that a proxy should be decided on 48 hours before the meeting. Clearwater Estates' problem was that the provisions, i.e. Articles 13.710 and 13.711, clash with Section 58(1) of the Companies Act that state a proxy may be appointed at any time. So, in my opinion, the court chose a fair route while making sure to follow the law. According to Section 15(1) of the Companies Act, a provision of a company's MOI has to be consistent with the Companies Act. Clearwater's MOI says a proxy is to be appointed 48 hours before a meeting, but Section 58(1) says a proxy is to be appointed at any time. So this is why it seems the ruling is in Clearwater Estates' favor. The very articles that Barry is relying on aren't consistent with the Companies Act, particularly Section 15(1). Because the articles or provisions aren't consistent with the Companies Act, Articles 13.710 and 13.711 are void because the articles are inconsistent with the Companies Act. So, I've gone through the case and analyzed it to the best of my ability in my capacity as a law student. My analysis might not be perfect now, but I tried my best. As I've said, I've included a link to this case, link to the Companies Act, so feel free to read the case, go to the Companies Act, and feel free to share your opinions with me. You can email me at rianoted@gmail.com or you can leave a comment on the video. Either way. Okay. If you are a regular viewer, you kind of know I hate littering. My mantra has always been stop littering. Please stop littering, guys. We have one planet, so let's all do better. Stop littering and look after our planet. Don't litter, do better. Alrighty, I hope you guys enjoyed this video. Don't forget to comment, like, subscribe. This channel is my daily bread, you guys. I've turned it into my job, so help a lady out by subscribing. I hope you guys will stay tuned and that you will watch my new videos. In closing, I shall say, first, thank you for listening. Second, don't litter, do better. And lastly, see you soon. Thank you so much, NoteTakers. Until next time.